All right. Everything's kind of moving around on me. All right. This is We the People News. Not attorney. My internet slowed down on me. Let's try this again. All right. Let's see if it's going to go to the original one again. Back up here. Let's go ahead and finish that off. See if the internet will work.
Discover Snowland at Great Wolf Lodge and create unforgettable memories with your pack.
It's really kind of funny how my internet kind of does that when there's certain things that's contradictory to law and kind of like secrets that's been let out.
We can stream local news, sports, and events. Agreed with the prosecution that it was okay for them to pull him out of the car and that he violated something by not giving his ID, not giving his information. Do you understand how wrong that is? That's what the judge did. She's like, oh, he was wrong. Go back and watch it. He is wrong. We're not saying that he wasn't. Yes, we are. We are saying that those cops were wrong.
Ha! I don't know what happened just there.
On the way to Arlington National Cemetery, nursing students from Brigham Young University.
Well, he didn't do it, man.
And I'm going to still go a step further, okay? In the Fourth Amendment, it says for description, okay? The Founding Fathers, they did have names, but they never put it in there to say, hey, you must give your names. You must identify yourself. Why? The Founding Fathers designed it supposed to be hard to convict even criminals, let alone innocent people. And the reason why it's supposed to be hard to convict criminals is to make sure absolute innocent people did not mistakenly go to prison, which we have known 30 years later that innocent people has been released. How many innocent people that's been put to the death penalty? Texas. Huh? I have a family member who's put to death. Never mind, you're going to get me started.
Okay, we're going to keep going. It's procedural safeguard. Number 3, the Texas Transportation Code. Although requiring a driver's license for operating, we know what that word means now. Within both years in Blacklaw's dictionary, a motor vehicle, we know what a motor vehicle now. It must, both of those terms are in relation to using the roads in commerce. On public roads is well established under Texas law. Texas Transportation Code. That's why this transportation code is transporting goods, property, or anything else while using the roads. Yeah, come on, we've already gone through this. Y'all know what it states. The defendant's argument regarding the right to travel might at least have warranted legal scrutiny. The failure to raise proper statutory interpretation argument challenges the applicability of certain regulatory requirements that the defendant was not engaged in commerce, represents a missed opportunity by the defense counsel.
And I do agree 100% with this guy, right? At least the defense counsel should have put some form of effort in this, instead of just complying and agreeing to all these other terms to try to wiggle out of these things. Why is she a defense attorney if she's not going to defend anybody?
Judicial conduct violations. So number 1, Texas Code of Judicial Conduct. Canon 2A, a judge shall comply with the laws and should act at all times in a manner that promotes public confidence in the integrity and impartiality. It doesn't say just integrity, it says impartiality of the judiciary. making biased prejudicial comments, or dismissing constitutional claims without reasonable analysis may constitute these canons. You simply saying that YouTube and all this, that has no relevance whatsoever to legal canons, specifically 2A, that you are supposed to abide by. Canon 3B5, a judge shall perform duties without
Right. Facts and the law. It's the same process as the jury. The jury judges the facts and the law. Not just facts and just leave that good. Not just law and leave that good. Facts and the law.
bias or prejudice. He's already violated. This case is out. Throw it out. It's done for. It's done. But because this individual doesn't know his constitutional rights, because he hasn't studied completely, he has allowed himself to become an infant and a ward of the state by allowing somebody else to represent him rather than him presenting himself and standing on all that he is, because he holds all power, because all power is inherent in him, right? When this judge says, you just don't seem to want to accept authority. Well, Your Honor, I don't think I have to accept any authority until I've done wrong or brought harm into another. If I am simply living my life free, while not engaged in any harm whatsoever, why do you think one can tell me, man, yo? If the judge's comments are seen as revealing bias, clearly they are, or a predetermined view of the defendant's guilt character, a motion to recuse under the Texas Rules of Civil Procedure extended to criminal procedures by analogy, or Chapter 30 of the Texas Civil Practice and Remedies Codes, will be warranted. Attorney conduct violations, Sixth Amendment and Strickland standard. Defense's counsel inaction does meet Strickland versus Washington test for ineffective assistance if shown that the counsel's performance was deficient and prejudiced the defendant's right to a fair trial. Texas Disciplinary Rules of Professional Conduct, Rule 1.01, competent and diligent representation. She was not competent, nor was she diligent in any aspect. Counsel should possess or acquire the legal knowledge, skill, thoroughness, and preparation, which there was none. You can tell she did not cite anything. No rules, no procedures, no constitutional violations. She came in there and blabbed about her sister being the assistant chief of police. Man, that holds no legal. Coming here talking about he's a black working man. What? Or that his lack of knowledge in relation to his constitutionally secured liberties. Man, what? In preparation, reasonably necessary for the representation, failure to file suppression motions, object to unconstitutional conditions or challenge the bias, or raise substantive legal arguments may contravene this rule. Rule 1.03, communication. Counsel must keep the client reasonably informed. A lawyer who fails to explain the basis for the charges or the possible constitutional defenses is not providing adequate counsel. Federal civil rights violations. This is what we are speaking on, is all of these violations are coming off just what we've seen. Just what we watched. We ain't even talking about what happened with the police. We're talking about right now just the aspect of how it is truly supposed to go, and how we need to educate ourselves more to get away from the aspect of not knowing. Like, we have to know our liberties, because if we don't stand on them, we waive them. We waive them. When they make a statement, like he said, you are not allowed to drive, and I don't care if you call it driving or traveling, and he is giving his biased opinions, you need to rebut that. Objection, Your Honor. I'm objecting right off the bat. We are getting it clear. So, 42 U.S.C. Section 1983, this civil action for deprivation of rights. If the defendant, which he did, suffered a deprivation of constitutional rights under the color of law, and if judicial and prosecutorial immunity does not apply, prosecutors have immunity for certain official acts. Judges have immunity for judicial acts, but certain egregious conduct may be subject to civil rights review. A civil action under 1983 might be contemplated. So the conclusion of all of this is The transcript reveals several potential legal and ethical violations, constitutional infringements under the 4th, 6th, and 14th Amendments, violations of the Texas Code of Criminal Procedure and possibly the Texas Transportation Code regarding the proper applications of licensing laws, breaches of Texas Code of Judicial Conduct by the presiding judge, failures of defense counsel under the 6th Amendment and Texas Disciplinary Rules of Professional Conduct, and the specter of professional prosecutorial overreach implicating the Due Process Clause and fundamental fairness principle. By referencing these constitutional provisions, statutes, and conduct codes, one can identify legal grounds on which the defendant's rights have been compromised and upon which counsel was obligated but failed to act. So that's one of these videos, okay? There's going to be another very soon that I'm going to be uploading. Maybe tomorrow, maybe Monday, okay? But I wanted to bring this to your attention to notice that this ain't even deep into ChatGPT as far as the O1 model and what we are going to be able to do to help people, okay? We're going all the way around now, y'all. We not finna play no more. We have to realize our liberties. We have to stand on those and stop playing with people, because this next one's gonna get even worse. The next one is actually an attorney who does stand up, okay? And you can see just how flip-floppy this judge gets as far as he shuts up and starts to obey when things are brought up correctly. And it's one of the most fascinating things that we can cross-reference to see the difference between one lawyer and defendant who doesn't know versus a lawyer who knows and will defend very heavily and shut that judge up. Same judge, by the way, too. So I'm just going to say this at the very end of this. Hey, y'all be sure. The right to travel course is now free, y'all. Okay? It wasn't. That's free. The description, or the link is in the description. I also wrote a book. I just released it last month in November. It's called The Last Tread. It's about all of my experience over the past 9 years, traveling with no license, no registration, no insurance, and no title. Okay? That's how it goes, y'all. And then, what else do we got? We also got the Traffic Law Reform Petition, which is a campaign that we have developed. All you have to do is go to change.org. The link is in the description. You sign it. And what we're going to do is we're going to forward all of that over to our representatives, our legislators, all across the United States to get traffic law reform and decriminalizations of all of that. Because remember, traffic law is in relation to commerce. And we need to start rectifying and getting this addressed, because we're seeing too many lives being lost. And then one other thing we got going on that starts tomorrow now, if you're watching this today, on Saturday, the 14th of 2024, tomorrow at 8 a.m. Pacific Standard Time, we are beginning the most coolest project ever, which is Operation Wise Dome. And Operation Wise Dome is amazing because we have 20 foundational members who are going to donate $10 every month to get ChatGPT's full O1 model unlimited use to formulate these types of things: overviews, analysis, deeper. And this is nothing. This took me 5 minutes. I could literally take another 10 to 15, 20 minutes and get really deep to draft up a complaint based on this transcript alone, naming all of the parties involved in their constitutional violations to pursue a state or federal civil suit. And this is the point where we're at. We don't have to depend on these horrible attorneys and lawyers anymore at all. We need to depend on ourselves, and it's all based on knowledge, with respect, honor, morality, integrity, all the way. Right? Allowing the great creator to work through us, because I am you and you are we and we are us. All a part of the great I am. And all power is inherent in us, we the people.
All right.
AM Pacific Standard Time.
Let's see here. We'll pause. Okay. Power inherited in the people. Okay. Check him out. Give him lots of love. Buy his books and all that. He's went through the test. That being said, he's not done yet, because, well, officers are allowed to be ignorant. They're allowed to be willfully ignorant. I got firsthand knowledge when I challenged an officer, and he says, well, why would I read the document? That's willful ignorance, people. Shouldn't think about it. All right. Till next time. This is We the People News. Bye, y'all.